Mr. Bash, you're saying, well, look, this is compensatory. Here are all the ways we can see that it's compensatory. But I think the opposite argument is that just doesn't get you home, because a compensatory system can have punitive, it can be part of a punishment scheme. And indeed, there's a theory behind this, right, which is you're forcing the defendant to confront the nature and the extent of the harm that he's committed, and that is a powerful way of driving home his wrongdoing. So, you know, to say it's compensation, it's like, okay, it's compensation, but compensation can be a form of punishment.
Well, Justice Kagan, I don't think we need the rule as broad as all forms of compensation are not punishment. I think that would be open to the court and consistent with its precedents, but I don't think you need to do that. I think you can distinguish the VWPA and the statutes like the one at issue in Kelly that say in imposing a compensatory remedy, don't just look at victim loss. Look at what's best for this defendant, what's going to promote the purposes of criminal punishment and deterrence and so forth. But when you have a regime that's essentially just a mechanical compensatory regime, I think under this court's precedents like Marcus and Helverian versus Mitchell, that's non-punitive. And I go back to—
I'm wondering why. If the whole idea of the theory is that it's punishment when you force the defendant to confront the extent of his wrongdoing, what better way to do that than to make the restitution scheme entirely focus on the defendant's loss?
Well, Justice Kagan, let me try it this way. I mean, 3664L allows victims to take advantage of the collateral estoppel effect of the criminal judgment in bringing a separate civil suit. So you can imagine a system where the victim, it works exactly the same way as it does here. But the victim just goes under a different case number, maybe even the Attorney General initiates it or maybe not, and just invokes the collateral estoppel effect of the judgment, and everything's the same. It's a compensatory remedy. It's offset by civil judgments, all the same features here that are laser focused on compensation. I think it would be pretty clear that that's a typical civil compensatory statute. And so the question is, does the fact that Congress arguably, and I think it's only arguably, made this part of the sentence or part of sentencing proceedings change things? And I think the government has to admit that that can't be the line, because a lot of civil things are imposed at sentencing through conditions of supervised release. This court hasn't decided that question before, but lower courts have almost uniformly said that DNA testing, these are ex post facto challenges, drug testing, you know, consent to certain forms of searches, those are all civil things imposed at sentencing because they serve non-punitive goals. In those cases, it's preventing reoffense or reintegration into society. In this case, it's compensating for harm in a way that I think is materially indistinguishable from what the tort system could provide.
Except in the tort system, if the victims receive insurance or some other